waiting for some latecomers to be seated, Mr. Williams.
Thank you. Good morning.
Kia ora tātou, good morning and welcome to everyone. The first business for us this morning on day 12 of these hearings is the submission by Fonterra, and I call upon Mr. Williams.
Good morning again, sir, and to the panel. I might just go down the table and let them introduce ourselves, so most of these people will be familiar to you, so as much as anything for the transcript and YouTube clip. So,
Gerard Willis, consultant planner.
Neil Thomas, hydrogeologist.
Bridget Buckley from Fonterra, the National Policy Manager for Manufacturing.
Yeah, and Mark Firth, I'm the Environmental Manager at Fonterra Canterbury.
Thank you and good morning to you all.
So
now, we have from you the original submission, a further submission, an evidence statement by Ms. Buckley, one by Mr. Thomas, one by Mr. Willis, and we have legal submissions that you presented in writing a few days ago.
yes, sir, I think that's the full suite, and just for completeness, I know Mr. Firth is here from the site to answer any specific questions, but you don't have a written brief from him, so...
That's right, yes, but we have all the others, and we've read all of the others, yep. So that none of you needs to read your statement to us. But you can manage with your own and the others' parts if they are to be making any introductory remarks.
Yep.
And then when it's convenient, we'll come to questions.
Thank you, sir. So in the case of my legal submissions, as much as anything, the purpose of these, and particularly following my Dairy Holdings presentation in my personal capacity a wee while ago, there's been quite a bit of discussion between both my witnesses and myself re the ECAN memo. In terms of a general proposition, the groundwater allocation issue here has probably been the hardest one to get my head around in terms of the wider land and water regional plan process I've been in. I think the ECAN memo does address the allocation concerns we've had. But in terms of putting forward a suite of plan provisions to actually articulate what I think is the common position as between Fonterra and ECAN, still quite hard. So what we put forward in evidence, as we understand it, is a regime that will properly reflect and protect Fonterra's position. So as you would have read from evidence, Fonterra has actually gone and done pump testing and confirmed the status of its water takes as most likely, if we understand the position correctly, a category take. And we've set out in the legal submission the concerns re the T allocation, but also acknowledge that were the panel minded to go down that track, it's not going to preclude Fonterra's continued operations, at least as we understand the position as best we can. So beyond that, I'm not proposing to do any form of summary. I'm conscious that the panel's hopefully, and I'm assuming, closely read my legal submission, and I think our evidence pretty comprehensively deals with the issue as well. So I'm happy to take any questions. Or we could...
Yes, well, thank you, Mr. Williams. I have a question that arises out of the original submission.
Yep.
And perhaps my colleagues will forgive me if I ask that while I have it in my mind.
Yeah, I will try and answer that or defer to Mr. Willis, who was also involved in the preparation of this. So.
Yes, well, of course. And I'm entirely comfortable if either or both of you answer. If I can make a coherent question, I'll be doing well. But I'm looking at the submission point number 2,
yep,
which concerns policy 14.4.8.
Yep.
And in the 5th column, which is headed comments, in the 3rd paragraph, not to say that the plan should not seek to phase out over-allocation, but the means of achieving that must safeguard the ability for Fonterra to replace its existing groundwater tanks. Now, I wasn't really getting the grasp of that. Does Fonterra say that it is entitled to replacement consents when existing consents expire?
No, sir, and I think I might make a general comment in respect to this as well. So, in respect of both our submission and further submission, and for that matter, our evidence, we were at that time going on the notified version of the provisions, and it had a lack of clarity around where the Fonterra water takes sat as against the A allocation block or the T allocation block. So I think, in short answer, sir, no, but this paragraph has now been overtaken both by the ECAN memo and the fact Fonterra has done the technical assessment to confirm it is within an A allocation take. So I certainly,
Yes.
I certainly accept that there might be a scenario where at a connected stream water take, for example, in the context of that paragraph, that you might look to, as the general approach to the plan does, to reduce over allocation over time.
Well, they might. A consent authority might.
Yeah.
It's just a matter of keeping in mind that because all of these water consents are for fixed terms and they're required to be for fixed terms, when an application is made for a replacement term, that needs to be considered by the relevant consent authority at the time on the circumstances, both legal and environmental, that pertain at that time, and so you can't say they must have it. They'll no doubt have a strong case for it,
Yep.
but legally they're not entitled to it as a right.
No, absolutely, sir, and I certainly acknowledge the operation of Section 124 and associated sections, and as you've referred to, sir, or the value of existing investment might be a relevant consideration in that process, but there's certainly no assurance that you're going to get a replacement consent on exactly the same terms, despite over-allocation in some instances.
Thanks, Mr. Williams. Commissioner Van Voorthuizen, do you have any questions of Mr. Williams?
Yes, just one series of questions really at your paragraph 21. And in your verbal comments, you've referred to the ECAN memo, which is the memorandum of 23rd September outlining the new method of calculating existing allocations. So two questions arising from paragraph 21. Was it still Fonterra's position that there should be a single allocation block for the Orakipaoa groundwater zone?
So what I've put forward in the legal submissions is what's probably best described as a preference for a single allocation block, which is perhaps I referred to in terms of the context, or in the context of the ECAN memo, a modified option 1. And I've set out in the legal submissions the basis for that modification, which is explained in that paragraph 21.
Yeah, I understand that, but my
RDA
question was, is that still the relief that Fonterra
Yes.
seeks? Okay.
But I do want to emphasise, as I said in my brief introductory comments, that in the context of Fonterra's narrow interests, I think any of the three options will address its position. I've tried to avoid, in the context of this legal submission, rewriting or putting forward wider recommendations for the wider plan, but I have also tried to assist the commissioners as much as I can within the scope of the Fonterra submission in terms of providing some guidance and thoughts around that. So.
I understand that. The question is simply because we have other submitters, including one sitting behind you, who advocates for a different position.
Yep.
For a T block. So now you say in the rest of paragraph 21, that if there is a single block, it should be restricted to replacement takes and to takes that surrender as surface water, etc. Given the current situation based on the 23rd September memorandum that there is still groundwater available, is that still Fonterra's position?
Yes, and Mr. Thomas and Mr. Willis might be able to talk to this too. The complexity arises because we still have a surface water allocation framework, which is, I don't think there's any uncertainty over that, and the ECAN memo doesn't deal with it, but there is significant over-allocation in the surface water allocation block, and obviously some of that will include stream depleting groundwater takes as well. So I think it's important to also recognise that although if you look in groundwater as it is at the moment in a narrow sense, there's still a need to address that surface water allocation issue as well. So which we've tried to reflect in the RDA rule approach with replacement or surrender consent. So putting some controls around the circumstances within which consents can be applied for is still sensible to protect as much as anything that surface water or reduce over allocation in the surface water allocation block over time now.
Okay. So the answer is yes, and the reason is you think that will assist with enabling a reduction of the current over-allocation of surface water.
That's right.
So in that regard, should the available allocation be available to new consents who are seeking to surrender direct surface takes, if they are seeking deep groundwater?
And that's the reference to surrender of surface water of direct higher with moderate stream depleting groundwater takes there. So.
Oh yeah, it's just that refers to stream depleting, but if it was a direct take from a river?
Yeah, so Mr. Willis may want to comment on this in due course. So we haven't tried to, beyond the stream depleting context, we haven't put forward any relief regarding whether reducing pure surface water, if you like, over time is a better outcome as compared to increasing groundwater. So.
Yep, no, that's fine. Okay, no, that's all I wanted to ask you about. Thank you.
Commissioner Solomon, do you have any questions to ask of Mr. Williams?
No questions from me.
Thank you.
Thank you.
Well, thank you indeed, Mr. Williams, for your legal submissions. We're grateful for those.
And I'll now pass to Mr. Willis, who I think is going to approach things on a similar basis. So.
Thank you, Mr. Willis.
Just move the microphone for your benefit.
Good morning, panel. Can I just, before I start, make one correction to my statement? Can I find it? On page 13 of my statement of evidence, I suggest some, what I'd probably say is sort of fine-tuning or clarification of Rule 14.59, and at the top of page 13 I provide some wording with an extra, essentially an extra clause, Romans 2 under A and B. Just in both those Romans 2 clauses, I refer to table 14ZA, and that should be ZB. The N. Hallford-Hausen has obviously picked that up already. So just if you could just note that would be grateful. I wasn't going to make much of an introductory statement. I think it probably covered the ground with the questioning of Mr. Williams. I mean, my view it really aligns with that. I mean, I have to say we did have a good long think and discussion about this and trying to work out what the best and most responsible course of action would be given the new information that came forward in the 23rd September memo, which did, I think, address a number of the issues that I'd raised in my evidence about the uncertainty and the apparent discrepancy in the accounting numbers. So my view really was that we now have a situation where, I continue to support the 71.1 million cubic metre groundwater allocation, and noting that allows, as I think one of the commissioners said earlier, a 6.9-ish million metric tonne headroom, if you like, which is there available for takes that aren't, would effectively be not replacement takes, but new takes of groundwater. My view is, well, how, I guess from a sustainable management and an NPS point of view, how can we best use that opportunity that now arises to address the question of over-allocation, and the theory behind, I guess, the T allocation, which was to allow new groundwater allocation in a swapping situation, still seemed to me to be the relevant principle to apply, but that we didn't necessarily need to go to a separate T allocation to achieve that. And my view anyway was that we could achieve that outcome, maximising the reduction in surface water over allocation, simply by changing the rule that applied rather than a separate allocation, which I think would lead to other difficulties, as both myself and Mr. Thomas point out. So that's my essential position on that, really confirming what you've just discussed with Mr. Williams. The other point, of course, that my evidence deals with is the separate issue of nutrient allocation. I won't go through those points. As I say, hopefully they're reasonably well discussed in the evidence. They are, though, I'll just make the point, they are, I think, really mostly questions of just clarification and hoping to remove sort of uncertainty rather than any significant policy changes being sought there. So that's really all I need to say at this point, I think.
Well, thank you very much, Mr. Willis. Any questions, Commissioner Van Voorthuizen?
Yes, just two matters. The first one arises on your page 12. And you're seeking a change there to Rule 14.5.10, which is a drop-down rule from 14.5.9. And have you got the plan there with you?
I do.
So if you see Rule 14.5.9, it has three conditions. The third condition relates to bore interference effects.
Yes.
So if we were to make the change that you suggest to the chapeau of Rule 14.5.10 to restrict it to replacement takes, that would have an unintended consequence that new takes wouldn't be required to have no bore interference effects, because your change would restrict that rule only to replacement takes.
It would help if I look at the right rule. Look, I take your word for it, because it's one of these things that takes a little bit of thinking through. It sounds right to me, and it may be something I've simply overlooked. I think, though, that clearly isn't the intent, and I could probably, if it would assist, have a think about that question and provide some alternate wording if that would be helpful to the panel.
Yep. Oh, absolutely. Anything that you can do to address the concern we have would be helpful. Thank you.
Thank you.
And just wanted to ask you if you could explain in kind of lay person's terms. You mentioned verbally that a single allocation block in table 14ZB would avoid problems associated with a T block. So what are the problems associated with a T block?
Yes, I'll have a crack at this one, and Mr. Thomas and I have been discussing that this week, so
Yep.
he may be able to answer this one better than I do. But I think part of the concern here would be that there is uncertainty as to the level of depletion that is occurring, and so a lot of that, as I understand it, the depletion status is modelled in most cases rather than as a source of pump testing. So when we come to replacement take situations and pump testing may be required or offered by the applicant, the status of those takes may change.
Mm-hmm.
So they may change from being low to or moderate up to direct or high, for example, which will which will then raise questions as to whether the allocation split between the A and T block is the correct one. And you may end up with effectively way more takes trying to get into the A allocation than in fact you've anticipated would be the case. I think essentially, and Mr. Thomas will say he may well be able to explain it differently given that he works with us on a very regular basis. But that's my understanding, and it seems to make sense to me that would be, you are having to make a determination as to which ones will fit into A and which ones will fit into T, and given that we haven't got complete information, that seems a reasonably heroic
Sure.
approach.
Okay. No, that's helpful. Thank you. You've raised the issue of moderate stream depleting takes in your evidence. So a question for the officers. Schedule 9 of the plan doesn't require moderate stream depleting takes to be subject to minimum flows. The wording of PC7 changes that presumption for this part of the region. Was that deliberate? And I'd like an answer to that now if you can.
I'll need to have a chat with our hydrologist if that's all right.
Yeah, okay.
I would like to check it out a little more
Sure.
thoroughly, but initially the intention I think should be that it should be the same as the rest of the alpha.
Same as Schedule 9.
Same as Schedule 9, but I will want to confirm
Okay,
that.
no, that's helpful. So, Mr. Willis, I think you suggested amendments to clarify that it should be the same as Schedule 9 by removing the word moderate from certain provisions. So, okay,
Yes.
that's great. But thank you for giving that quick answer, and if you could confirm that, that would be great. All right, that's all. Thank you very much, Mr. Willis, from me.
Commissioner Solomon, any questions for Mr. Willis?
No questions from me.
Thank you. We'll now move down the table to Mr. Thomas. So.
Thank you very much.
I'm happy just to take questions directly. I didn't have any additional statement to start with.
No introductory remarks, that's fine. Your evidence statement was clear as it came, thank you. Any questions for Mr. Thomas, Commissioner Van Voorthuizen?
Only if you think you could add anything to the answers given by Council and Mr. Willis regarding this issue of a T block or not a T block in the table ZB. Can you add anything to what's already been said?
No, I don't think so. I think I'd still suggest that a single allocation block makes more sense.
Yep.
And that it would be easier to manage
Yep.
than having a split allocation block, given that your A block could change. Yep.
Okay, no, that's good. Thank you very much. No further questions.
Thank you. Commissioner Solomon, any questions for Mr. Thomas?
Nor me, thank you.
Very well, thank you.
Thank you.
Well, we appreciate your evidence and the care you've taken to present it so clearly. Thank you, Mr. Thomas.
Thank you.
And now Ms. Buckley. So, what will move that one?
Thank you.
Sorry. Kia ora. I have no further statement, but happy to take questions.
Thank you. Questions for Ms. Buckley, Commissioner Van Voorthuizen?
No, none for me. Thank you.
Commissioner Solomon?
Yes, I just have one, or a couple actually. Paragraph 34, I'll just bring it up. At the bottom, the last sentence in paragraph 34, you talk about a new system to correct the pH of all wastewater. So I presume correcting the pH will improve the quality of the discharge, but will it neutralise it?
So just in relation to the pH correction, that relates to the discharge to the coastal environment?
Yes.
Yes. So my understanding is that it will reduce it closer to neutral, but not necessarily at neutral. So it enables us to comply with the current conditions in that consent.
And just out of interest, given Fonterra's ethos of continual improvement, and without knowing the quality of this discharge and what effect it has on the marine environment, are there any plans to remove the discharge to the coastal marine area outright, as they've done in other regions?
Great question. At this point in time, there are no immediate plans to remove the discharge from the coastal environment. However, we do understand that there will be significant pressure for us to do so in the future. Given the large wastewater volumes at Canterbury, it would be around additional treatment to remove further nitrogen to reduce the volumes of wastewater itself, so particularly the water component. And in doing that, we would need to secure more land around the area, which may prove to be a bit difficult in the near future, at least.
Thank you, Ms Buckley. That's all from me.
Well, thank you, Ms Buckley. I don't think then that we need to take it any further. Mr Williams, the commissioners find the constructive approach that Fonterra has taken to presenting its submission helpful and consistent with past practice.
No, thank you, sir, and always happy to help, and that comment does apply going forward as well. I'm conscious that this, particularly the ground allocation issue, there's been a lot of information presented during the hearing process, and perhaps what we would have liked, and the position has moved a lot from where things started. So if on further thought the commissioners want further questions or have want us to look at things further, please don't hesitate to get back to us. But thank you again for accommodating us today.
Thank you all for coming in.
Thank you.
Good morning, Ms Hornsey.
Good morning, sir. Good morning, Commissioners.
Did we come to the Orakipaoa next?
Yes.
Orakipaoa water users?
Yes.
Now, Ms Hornsey, how would you like to proceed? You're familiar with our practices.
Yes, if I may make a few introductory comments from a legal point of view, then Mr. Lister and Mr. Connolly provided a joint witness or evidence statement, and it's regrettable that Mr. Connolly is unable to be here today. That concerns him greatly. And he is available to come along at a later date should there be any questions for him. And then Ms Johnston has also provided evidence in this matter. Yes.
Well, thank you, Ms Hornsey. If you'd like to commence with your additional remarks.
Thank you. The relief being sought by the Orakipaoa water users is firstly that they sought more information, particularly around the cultural values of the area that has been classified as a high natural character water body in the plan, is notified. It's a significant stretch of the lower part of the river, and they had hoped that they would be able to engage with Te Runanga o Arawhenua more closely in identifying the cultural values, but regrettably that was unable to take place prior to the plan being notified. That being said, we note that in the further submissions of Te Runanga o Arawhenua and Te Runanga o Ngāi Tahu, that they have offered to provide advice and guidance on identifying those cultural values and to work together. And these submitters would be pleased to be able to take up that offer to improve their understanding of those values. The second matter is probably the most significant for the members of the users, and that is their amendment that they are seeking to Rule 14.5.4 as notified. They are seeking to be allowed that applications for replacement consents, that is currently consents that are being lawfully exercised, to be classified as a restricted discretionary activity rather than the non-complying activity that they are as the plan is currently notified. And I note that the panel requested that the Regional Council draft a bespoke rule to address this, and we support the adoption of the drafted bespoke rule, or alternatively just the simple addition to the existing Rule 14.5.4 sought in the original submission. It is our preference that a simpler approach be taken, but either would be satisfactory. In addition to that, I note that there may also need to be some amendments to other parts of the plan to ensure this section of the plan to recognise that this is an exception and prevails over the policies and rules in sections 4 and 5 of the plan. That is particularly policy 4.6, and would also seek that the words at the top of the table, 14.8, that identifies this particular area as one of being high natural character, that again those references to sections 4 and 5 of the plan be taken into consideration. The third remedy that is sought by this group is to retain Table 14T as it was notified. This is sought on the basis that they understand that the consents that they currently hold are included in that table. We note that when drafting the bespoke rule regarding this high natural character water body, reference was made by the Regional Council to the possibility of exchanging surface water takes or connected surface water takes for deep groundwater. However, as you'll have noticed from the evidence of Mr. Lister, that is not necessarily the case for this water users group. So I'm now happy to take any questions you have.
Well, thank you, Ms. Halsey, for that summary. Questions, Commissioner Van Voorthuizen?
No questions, but as you've alluded to, Yes, we are obviously thinking about this high naturalness water bodies issue, and of course we can't give any indication to where we might end up on that, but I do take your point that simple is better than not simple.
Thank you.
Commissioner Solomon, any questions of Ms Hornsey?
No, but I just want to say I'm pleased to hear that Tirunanga or Arawhenua are going to engage with the users of the Orakipaoa users group.
Just a question that you might be able to help me with, Ms Hornsey. The first of the three items that you've given us your summary, where the submitters were seeking more information, I can understand that, their point of view, but this is not, strictly speaking, a process where submitters seek information. It's a process where submitters propose improvements to the plan change that's been published. Do you see what I'm saying?
I do, sir, and perhaps I should have been more specific in terms of the way that that relief was worded in the submission. It was to assist the water users with understanding what cultural values they should assess and manage if they needed to make an application for replacement consent. And also possibly the extent of the area that is covered.
Well, I understand that, but that would be the water users' concern, shall we say, what they wanted. But this wasn't the process for getting that. This was the process whereby they could propose what they think should be the cultural values, and then we'd see whether there was any further submission bearing on what they propose.
Yeah, I take your point, sir, and they're certainly not in a position to do that without Arawhenua.
It's just that this is the way that this process is structured. Now, we've, I think, dealt with the matters that arise from your introduction. Thank you, Ms Hornsey. Which of the witnesses shall we go to first? Shall we go to Ms Johnson first or to
Yes,
Solicitor?
that suits the panel. Thank you.
No, what suits you, Ms Hornsey? We'll take whichever order you prefer.
Ms Johnson's ready to go, sir.
I am. Good morning, Commissioners.
Good morning to you, Ms Johnson. We have your statement, of course, and you understand that we've read it already.
Yes.
Are there any updates, corrections, or introductory remarks before we come to questions of you?
No, obviously I dealt with those in my summary of evidence that was provided in addition to my primary evidence, so I'm just happy to take questions from you this morning.
Thank you. Commissioner Van Voorthuizen, any questions of Ms Johnson on this topic?
No further questions. The issues are very much the same as for the Temuka catchment group, so no, nothing further to ask you about. Thank you.
Thank you.
Commissioner Solomon?
No, none from me either.
And none from me, Ms Johnson. I hope you don't feel that your attendance has been in vain. But,
not at all, sir.
the clarity of your summary of evidence has been helpful.
Thank you.
So now we can come to the lister, is it?
Yes, good morning, Commissioners.
Mr. Lister, are you going to give us some introductory remarks?
Just one correction, sir. It was my grandfather that was a pioneer of irrigation in Canterbury, thank you. Not my father, as it says in the statement.
And was that in relation to the Levels Plains irrigation?
No, simply in the area east of Temuka, in the Orakipaoa stream area, thank you.
Yes, impressive. Commissioner Van Voorthuizen, do you have any questions of Mr. Lister?
No questions here, Mr. Lister, and the points you make, I understand, so thank you.
Commissioner Solomon?
No questions from me either.
Well, again, Mr. Lister, I hope you don't feel that you're coming to see us today has been unnecessary, but as it turns out, we don't have any questions for you, and so we can thank you for your contribution.
I understand. Mm-hmm.
So, Ms. Hornsey, there's nothing further in respect of this submission, is there, that you want to raise?
No, thank you, sir.
So next, I think we're going to consider the submission of Barker fruit processing. Is that right?
Yes.
Just a moment while I pick out the materials that we have for that. So we have the evidence statement of Mr. Regan Vanu, is that right?
Yes.
Yep, that's correct.
Have I pronounced that correctly or adequately?
Yes, you have. Thank you.
And an update. So, Ms. Hornsey, would you like to proceed?
Thank you, sir. So the submission from Barker Food Processors Limited was prepared on the understanding that they may not fit the community water supply definition in the plan, and it's now, as you will see from the updated evidence of Mr. Regan Vanu, being confirmed by the Regional Council that they are regarded as a community water supply, and therefore the general rule under the plan, Rule 4.49, excuse me, applies. So the main concern has gone. However, Barker Food Processing Limited does wish to be recognised in terms of the water use that they currently use, but also seek that when any limits are set, that it is borne in mind that they are a water user and that they wouldn't want to be unnecessarily restricted in their operations. But again, given that they would not be subject to environmental flow and allocation regime restrictions, that initial concern has dissipated.
So that understanding as we can, because of your clear expression of it, that they don't want to be unnecessarily restricted when limits are set. That's really am I right in understanding that's really a future matter rather than a content of Plan Change 7 as such?
That's
Is that
right,
true?
sir, yes.
So that since our remit is improvements to Plan Change 7, I don't know that we can do anything about that for them.
No, they just wanted to be heard and recognised, and be assured that they will be able to continue to operate.
Yes, well, thank you. Well, in the light of that, I should ask my colleagues if they have any questions. Commissioner Van Voorthuizen?
Yes, just one. You mentioned that in light of the confirmation from ECAN that they're a community water supply take, that a general rule would apply, and I didn't quite catch the number that you said.
There's policy rule 4.49 and rule. I got the right rule. I might have to look that up.
So what was the first reference you made?
Policy 4.49 and rule 5.115.
Policy
4.49.
Yeah, and rule
5.115.
Okay, thank you. No further questions for you, thanks.
Commissioner Solomon?
No questions from me.
Well, thank you again. It seems that there's been resolution of these concerns, as far as we can take it at the moment anyway, and we're grateful for your contribution today.
Thank you. Did the panel have any questions for Mr. Regan-Vanu?
No, I don't think so.
Thank you.
Thank you.
Thank you.
Any questions? No.
No, not now that it's been resolved that they're a community supply take, that's fine.
So next we have the South Canterbury Chamber of Commerce. Are you representing them, Ms. Hornsey?
Possibly more introducing them, sir, rather than representing them.
All right. Well, please would you do so?
Thank you, sir. So the South Canterbury Chamber of Commerce has made submissions on this plan change and are seeking generic relief. Firstly, that due time be given for the changes to have to take effect, particularly as they relate to impacting on businesses in the South Canterbury region. And secondly, they are asking that the panel take care when considering any economic evidence that's put before them to make sure that it is robust and supports any decision-making processes.
Well, thank you for that introduction.
And with me, I have Mr. Handy and Mr. Grant.
Thank you.
They have prepared, along with Mrs. Smith, a joint brief of evidence and are here today to briefly talk to their evidence and to answer any questions that the panel may have.
Yes. Well, thank you. Just. Now, Mr. Handy, good morning and welcome.
Good morning,
Please
Commissioners.
introduce yourself and say what you would like to say in support of this submission.
Thank you, and good morning, Commissioners. And thank you for the opportunity to speak to our submission. I'm Gordon Handy, and I'm the President of the Chamber of Commerce in South Canterbury. It concerns the South Canterbury Chamber of Commerce that this proposal can be submitted without sound, robust economic data, because it's obvious it will have a major economic effect on our farmers and our business community. Post-COVID, local communities must have regional spend to support all of our rural communities, and with this rushed and ongoing implications of PC7, it's going to have a dramatic negative effect on our communities. Please consider giving us some time to work through these issues. The Chamber is also very concerned at the lack of local knowledge used in the production of this proposal. The local organisations, committees and advisory groups that have managed our waterways extremely well over the last 20 plus years. So why are they not listening to them and working with them to achieve the ultimate outcome for our environment and our communities? Thank you.
Well, that's an excellent summary. Thank you, Mr. Handy. Mr. Grant, are you going to add to that?
No, I have no statement at all. I'm just here to answer any questions if anything. It's good, Commissioner. Yeah.
Yes, thank you. And is Ms. Smith going to add something to it?
No, she's unavailable this morning, sir.
All right, well, if there's something different that you would like to add, you can ask for an extra time from the hearing manager. But otherwise, it seems that the statement we already have and Mr. Handy's summary of it this morning put us in a clear position of understanding this submission. Any questions of Mr. Handy? Commissioner Van Voorthuizen?
Yes, just one question at this written statement, paragraph 5.7a. You talk about the proposed minimum flow increases for the South Opua, the Upper Opahi and the Te Anawai. The plan as notified had two steps of minimum flow increases, one step at 2025 and one step at 2030. Does the Chamber oppose one or both of those steps?
I think it's probably more around the sentiments of increasing minimum flows and the financial implications that it will have on some of those farming systems without the alternative water sources, and that's really where the general feeling of the Chamber has sort of come about. So I mean, a lot of it's, I mean, we're asking for a time. Some of the rules have quite a short time frame, and if we had more time, it gives more farmers and businesses more time to react and adjust to some of these changes.
Okay. All right, so it's more the principle and then allowing time for farmers to adjust.
Yeah.
Okay, no, thank you.
Yeah.
Commissioner Solomon?
Yes, just on the matter of time, have you got an idea how much longer?
Oh, no, that's a really difficult one to answer, but I suppose another perspective as well, there's a lot of there's a lot of improvements that farming has made in the last 10 to 15 years, and I do believe that we're yet to see some of the effects of this change. As I'm sure you'll understand that, it takes a long time for the water to work its way through the profile, and surface water is quite reasonably quick to change once with riparian plantings and stock exclusion comes about. So it is a difficult one to know the timing, but it's just more monitoring as we go forward and understanding how things are tracking is really important. So,
Thank you.
thanks.
Can I just add to that, please? Also, that I think what we've seen post-COVID, and with the uncertainty in the rural sector at the moment over compliance and ongoing costs, it's starting to affect regional towns already. We're not seeing that spend coming from the farming sectors into the towns, and we're seeing a lot of pressure on business because that regional spend is not coming through. So it's very significant to us. Any help would be appreciated.
I have no further questions.
Thank you. So, gentlemen, and I'm not sure which of the two of you would like to respond to this, but the other important point that you made was your reference to economic evidence being robust. And I take it that in that regard, would you expect there to be someone who's got special qualifications to talk about economic matters and who's done some research, but who has done that not just looking to come to a particular conclusion, but to examine it in a more, should we say, academic sense? Is that the kind of approach you've got in mind when you say robust?
Absolutely. I think the data we've requested to see the actual true costs of this implication, we haven't managed to find actual data. And no one's really produced it, and the Chamber's not, unfortunately, is not in a position to produce that information either. And I think it's very hard to make an informed decision if you haven't got the accurate data.
Well, I think it's important that with the tasks that we have over Plan Change 7, a body such as the South Canterbury Chamber of Commerce should have come along, made a submission, presented a statement, and come and answered our questions. That's the way it ought to be done, and we're very grateful to you for doing that. Thanks indeed.
Thank you.
Thank you very much for your time.
Ms. Fernando, is there further business this morning?
No, not this morning.
So we have some other submitters to come in this afternoon, is that right?
Yes, that's correct.
So I'll adjourn the hearing now until 2 o'clock this afternoon.
Thank you.